Hello, everyone. Let's wait 30 more seconds for others to join before we start. Thank you. Before we begin, we'd like to go over a few housekeeping notes. This session is being recorded. The slides and recording of today's webinar will be provided in a follow-up communication. Please use the Q&A button at the bottom of your screen to submit your questions at any point of today's session. We'll be addressing these at the end of the presentation, and we will do our best to get to all of them. Okay, on behalf of Baker McKenzie and the IMT Group, welcome and thank you for joining today's webinar, Asia Pacific IMT Webinar Series, Customs, Audit and Disputes in Asia Pacific, Vietnam session. My name is Yaiko Hodaka, and I'm the co-chair of the Asia Pacific Industrials, Manufacturing and Transportation Industry Group of Baker McKenzie, based in Tokyo. We understand it is often the case that companies doing business in AP face various issues with local customs authority because of unexpected change of practice, arbitrary interpretation of laws and regulations, and suffers damages that may sometimes amount to a significant amount. So we decided to hold the series of webinars where our clients can understand the overall regulatory regime, current practice, and how you should prepare in each jurisdiction in AP. Today's session will focus on Vietnam. I'm pleased to be joined by my colleagues, Vinh Nguyen and Chun Chan from our Vietnam offices. Vinh currently leads our Vietnam tax and trade practice and focuses on advice, planning, and contentious matters on tax and customs and trade matters. Chun is a senior regulatory advisor in a corporate practice, specializing in international trade and corporate services. He also focuses on compliance, including transactional documentation, advising on tax, customs, technical barriers, and international commitments in the Vietnamese market. And now I will hand it over to Vinh, who will walk us through today's agenda. So Vinh.
Thank you, Yaiko. Hi, good afternoon, everyone. So as Yaiko introduced, I am Vinh Nguyen. I'm a partner tax and trade and customs, a partner of Baker McKenzie Vietnam. So today our webinar, we will focus on customs, audit, and dispute issues in Vietnam. The agenda will cover first, we discuss about an overview environment on customs audit in Vietnam. What are the procedures that you should be aware from the company perspectives. And then second, we move to the focuses on customs audit from the custom perspectives. Those are the areas that customs authorities are focusing on when they do audit at the company. And last, so if an audit happens, what can you do to manage the audit to minimize the impacts or exposures for the company? And last, so we have the Q&A session. So just submit your questions, and we will have a short Q&A session after the presentation. So now over to my colleague, Trung Trần.
Okay, thank you, Vinh. Once again, good afternoon and welcome to our today's session. Again, I'm Trung. I'm based in Hanoi, and I specialize in custom and trade issues for almost 20 years. The today topic, the custom audits, is a very common issue among importer and exporter. However, many enterprises find themselves confused when a custom audit occurs, because custom audit is not conducted on frequent basis for any single enterprise. So in this first section, overview on custom audit in Vietnam. I would like to walk you through some key issues that enterprise should be aware in custom audits. So next slide. So first, in Vietnam, when mentioning custom audit, it means two different audits. The first one is the post-clearance inspection, PCI. This PCI is governed under the law on custom. So it is a direct procedure under the custom practice. The other audit is the specialized audit, SA, which is governed under the law on inspection. So SAs can be applied to any sector, not only custom issues. Why PCI is an exclusive measure for custom audit in the field of custom. So it means that in practice, normally when talking about custom audit in Vietnam, it's mean about the PCI, because PCI is a more common and activity conducted by custom authority when they want to inspect the business activity in custom field of the enterprise. So next slide. For the PCI, so the statute of limitation for the PCI is 5 years. We mean that custom authority can come back to inspect any custom dossier or any consignment that imported or exported into Vietnam within 5 years by the date of the inspection. So PCI is conducted when custom authority detect sign of violation, or it can be conducted on the risk management basis or compliance verification purpose. So it means that it's not necessary to have any sign of violation, but as an annual plan, custom authority may randomly conduct the inspection or the PCI on the importer or exporters. Next slide. So for the PCI, there's also two different types of PCI. The first one may be considered as an entry-level PCI, is the PCI as Custom Authority Office. And the second one is the PCI at the Declarant Office or at the Importer or Exporter Office. The PCI at the Declarant Office is considered as more important or as compared to the PCI as the Custom Authority Office. In this nature, we can see that the duration of the PCI at the Custom Authority Office is shorter, only 5 working days. While at the PCI at Declarant Office, the inspection may last as long as 10 working days, and Custom Authority, they can extend it up to another 10 working days. So for total, it can last as long as 20 working days for the Custom Authority to conduct the PCI at the Declarant Office. So next slide. So the procedure, how is the procedure for the PCI to be conducted? So first, for the PCI at the Custom Authority Office, in order to conduct any PCI, Custom Authority, they need to issue a written decision. The written decision will be sent to the importer and exporter in advance in order to let the importer or exporter know about the PCI. So once receiving the PCI, the importer and exporter need to follow or comply with the requirement of by the Custom Authority as set forth in the decision. It means that for the PCI as Custom Authority Office, the importer or exporter need to present at the Custom Authority Office And if they fail to do so, custom authority, they may at its discretion to impose the penalties or escalate the case to the provincial custom department and update in the custom system as the non-compliant fact of the specific importer or exporter. So for the PCI's Custom Authority Office, it is not so convenient for the importer or exporter, because as you may know, in Vietnam, the main port for importation or exportation activity is located only in a number of provinces. For instance, Hải Phòng or Da Nang or Ho Chi Minh City. Meanwhile, most of the companies, foreign invested companies, are located in Hanoi, for instance, or Ho Chi Minh City. So if, for example, the Hải Phòng Custom Authority requests a PCI at the Custom Authority Office, mean that the importer or exporter located in Hanoi or Da Nang or any other provinces need to travel to Hải Phòng in order to meet and work with the Custom Authority in the PCI. So that is an inconvenient fact for the PCI at the Custom Authority Office. And once the PCI is completed, the Custom Authority, they will issue the notification, the result of the PCI. The outcome of the PCI, of course, is either they accept the declaration made by the importer or exporter if they can prove that the declared information is correct during the PCI. Otherwise, it would be rejected, and the Custom Authority, they can impose a set tax and duty, penalty, and late payment interest, if any. In the case that the Custom Authority, they cannot make the final conclusion, they may report to the director of the provincial custom department to take further action. And the specific further action here could be the PCI at the declarant's office. So next slide. Okay, so as a higher level on PCI, the PCI at the declarant's office basically undergoes the same process as the PCI as the Custom Authority Office. That said, the PCI at the declarant office is not subject or dependent on the PCI at the Custom Authority Office. For Custom Authority, they can decide whether they will conduct the PCI at the Custom Authority Office or the PCI at the declarant's office. It's not necessary in the order that first must be the PCI at the Custom Authority Office and then to the PCI at the declarant office. So well, it means that it's not that these are two independent processes and are not subject to each other. So again, again, for the process, first is also the issuance of the decisions. And then the custom authority, they won't conduct the PCIs as it. And for the result, of course, it a little bit different here in the PCI at the declarant office. So in the PCI at the Custom Authority Office, they issue the result notification immediately without any consultation or comment from the declarant. But here in the PCI at the declarant's office, they allow the importer or exporter to make command or make any change to the conclusion. So it means that they will send the importer and exporter the draft of the result conclusion first. And the importer and exporter will be allowed to make their comment and their opinion. And in this aspect, Vinh Nguyen, my colleague, will provide further detail in later section. So it means that this is the key point, the key difference between the PCI at the declarer office and the PCI at the custom authority office. And then once the declarant make the command, the custom authority, they will finalize the conclusion. And again, the outcome, it could be accept or reject the declaration. However, in the case that the custom authority, they cannot make the final conclusion, they will transfer the case to the specialized audit, the SA procedure that I mentioned earlier. So here, next slide. The SA, the specialized audit. So again, specialized audit is a process governed under the law of inspection. So it is independent from the PCI. However, it is considered as a higher step as compared to the PCI. So here for the SA, the decision maker, it must be the General Director, the GDC, the General Department of Customs, which is the centralized government authority that governs the nationwide custom activity in Vietnam. Or the director of the PCI of the department, which is a department under the GDC, or even higher, the decision must be made by the chief inspector of the Ministry of Finance, the MOF, which is the authority that governs the GDC. And because of its importance, the duration for an SA is much longer. As you can see here, the duration at the ministerial level, which is the duration for the SA conducted by the MOF or the GDC, it could last as long as 45 days to 70 days. And at the provincial level, which is the SA conducted by the chief inspector of the provincial custom department, it could last for 30 or 45 days. Of course, that it's not necessary that the whole process here, 45 or 30 days, is conducted on a single enterprise. Because normally when an SA occurs, it normally requires an inspection on a wide spectrum of enterprise, not only one single enterprise. And the duration here is for all of these subject of the SA, not necessarily be on one single enterprise. Next slide. And again, the process here, it is somehow the same as what you have seen in the PCI. First, they will need to issue the decision, and then they will come visit the office of the importer and exporter to collect the information, the document, and they may come back to the office to conduct the analysis, the observance, and then after the SA, they will provide the result under which they will give an overview on the importer, exporter, the result of the inspection, and they may propose the measure to apply on the importer and exporter. And in this aspect for the measure here, it's not necessary to be the penalties only, but they can advise or propose other measure, like from a macro level measure, for instance, or a policy measure to address the issues or to address the result of the SA. So next slide. So as you can see that custom audit is, it could lead to substantial consequence when it's conducted. Therefore, a measure for importer and exporter to mitigate the risk of custom audit is voluntary disclosure. So voluntary disclosure here in Vietnam is not well developed. However, it is there, it is in place to a certain extent in the current regulation. So for instance, here importer and exporter are allowed to conduct any amendment or supplemental declaration to what they have declared to the custom authority within 60 days of the import or export. And in such case, there would be no penalty. So you can come, check, and amend what you have provided to the custom authority within 60 days from the import or export of the consignment without any penalty. However, if the importer or exporter conduct the supplemental declaration after 60 days or before any PCI, then the 10% penalty of the tax shortfall shall apply. If importer or exporter voluntarily pay the tax shortfall after the PCI is completed, which means that the custom authority, they already came, they check, and they provide the importer and exporter their conclusion. And at this stage, if the importer and exporter voluntarily pay the tax shortfall, then the penalty is 20% tax shortfall. Otherwise, at this stage, if the importer or exporter refuse or reject to pay the tax shortfall, custom authority can commit it as a tax evasion, and the penalty would be 1 to 3 times of the tax shortfall. So next slide. Another measure of to mitigate the risk of custom audit is advanced ruling. So here under the current regulation, the advanced ruling include the advanced ruling of the HH code, the custom value, and the origins. However, in practice, custom authority, the GDC, only offer the advanced ruling for HS code. So importer and exporter, they can only apply for advanced ruling for the HS code. It is impossible to apply for advanced ruling in custom value or advanced ruling in origins. So that is the disadvantage. And even for the advanced ruling of the HH code, custom authority is now proposing some amendment or limitation, particularly because now only GDC, which is the centralized government of custom issue in Vietnam, only GDC provide the advanced ruling. It leads to an overload and time consuming. So the regulatory timeline for an advanced ruling is 60 days. However, in practice, importer and exporter may have to wait as long as 6 months in order to receive the advanced ruling decision. And now GDC proposed to limit it down that only importer or exporter that conduct the first import or export of a specific commodity, only such importer or exporter are allowed to apply for advanced ruling. Any import or export that already import or export the same commodity before, they will not be eligible for the advanced ruling application. So next slide. So that's all about the overview. And in this second session here, custom audit focus, I would like to present the trend and also some major key areas that custom authority will focus when they conduct the custom audit. So next slide. So first, talking about the trend. Actually, in Vietnam, the law on custom already in place since 2014, which is 8 years ago. And so far, there's no update on the law. There's certain update at the subordinate legislation, such as the decree or the circular, but the law itself remains the same for the last 8 years. Therefore, when discussing about the trend, it is quite difficult to identify which trends is currently in place here in Vietnam. In principle, the custom authority, they develop a list of high-risk goods. That are the goods from their experience, from the database, they see that such goods have risk in a violation. And the risk here is also very diversified. It could be risk from origins, or risk from the custom value, or risk from fraudulence or tax evasion, etc. And this list consider very wide range of commodity in any sector. So it means that, for instance, for the cosmetic industry, it's not all the cosmetic products are high-risk goods. There's only a number of products in the cosmetic industry appear on this list. So you can, it could be said that there's no particular trend or particular industry focus for the custom authority when they conduct or they plan for the custom audit in any particular year in Vietnam. And this list, of course, it could be changed from time to time on the basis of what happened in the last year, in the previous year of the list, and then they see that if the list now is outdated, they will update it. And they can train the focus on which commodity, specific commodity, on the basis of that list. So next slide. So the first issue, and also maybe the number one issues here for custom audit in Vietnam, is the custom valuation in related parties of transaction. So we all know that now among the foreign invested company, related party transaction is very common. When parent company established a subsidiary here in Vietnam, and they conduct the business through the subsidiary. So in the common form, related party transaction won't be a sale and purchase agreement or a distribution agreement under which the optional seller will sell the goods, the commodity, to the local importer, and the local importer will conduct the distribution of the goods in Vietnam. And the optional seller and the local importer are related party, and the agreement may be an exclusive distribution agreement, which is the local importer is the only entity that import such commodity in Vietnam. And as we know that normally in related party transaction, there won't be transfer pricing compliance requirement here, at least for the optional seller. But unfortunately, here in Vietnam, the custom authority, they completely ignore the TP issues or transfer pricing issues. So it means that in any manner, once the offshore seller, when they comply with the TP arrangement, with the local importer, and such TP arrangement is indicated in the agreement between the offshore seller and the local importer, then that can be the issue, the challenge that importer will face by the custom authority. So normally when in practice, when we see that the first signal or the first sign for the custom authority to notice on a particular related party transaction is that the importer fails to declare the related party relation during the custom declaration. Most of the company now they assign this work to logistics service provider, and maybe due to negligence or some other reason, they fail to declare the related party relation on the custom declaration form. Obviously, failure to identify or notifying the related party relation is not a reason for custom authority to reject the custom value. However, this is the first sign for custom authority to focus on the transaction. And once they focus on the transaction, they will review the agreement. And if the agreement have some kind of some provision on the specific profit margin the local importer will receive from this transaction when they conduct the distribution here in Vietnam, which is something that are very familiar and common for TP issues, then that would be a pitfall for custom authority to reject the custom value, with the reason that a normal transaction or an independent transaction will not secure a profit margins for the buyer, which means that in the condition for the custom value to be accepted, among other, is that the transaction is conducted similar as a transaction between independent party. And the custom authority, they will argue that in normal transaction between independent parties, the seller will not commit a profit margin for the buyer. And that is the first pitfall here. Other legal issues that can be challenged and other reason for the custom authority to reject the custom value is that the buyer, they propose the buying price or the purchasing price, and custom authority they argue that in normal transaction it is the seller to propose the price. It should not be the buyer to propose the price, and because that's they argue that the transaction is not normal and they reject the custom value. Other similar reason is that, well, if the seller provide an unspecified discount to the buyer, because here in Vietnam, discount, commercial discount should be based on the quantity, whether or not the importer buy a large amount, or the payment, whether or not the importer will pay one-off or pay sooner as the schedule, for instance. So that there must be a reason for the discount. If the seller simply offer a discount without any commercial basis, then custom authority, they can focus on that and they consider that this is not as normal as an independent transaction, and they reject the custom value. And also the last reason we can see, the last key reason you can see is that in certain case, the seller, the also seller still maintains certain control on the imported goods once it was sold to the buyer. It can be seen in certain provision of the agreement, such as the warranty. Here is not the warranty between the seller and buyer, but the warranty can be extended to the second buyer. That is the buyer that purchased the goods from the first buyer. So these are some key issue that we can see that in custom value in related party transaction that the custom authority will focus on and uses as a reason to reject the custom value. So next slide. The second one, the second issue here is the HS classification. So normally importer, when importing some commodity here into Vietnam, they will conduct a declaration on the basis of the HS code as provided by the exporter. It's not all 100%, but in general, it would follow this flow, which is importer, they not themselves invent a HS code, they will follow the exporter. And custom authority, what they will do, they won't try to identify the same heading, HS heading or HS subheading so it's at 4-digit level, 6-digit level, HS code with higher tariff rate, higher import duty rate. And they challenge the declare HS code. This is common in the case that there's no legal or common description on certain terms of the goods. For instance, we don't have like a legal definition what is control panel or what is switchboard, for instance. And in certain case, if the switchboard had a higher import duty rate as compared to that of the control panel, the authority, they won't try to challenge that. It's not a control panel, it's just a switchboard, and they impose the SI code and switchboard for the control panel as declared by the importer. So that is one common practice here. The second common practice is about the ingredient. So it's normally in the mixture. When the custom authority, they won't try to rely on the ingredients of the products or the material of the products to impose the AS code, a different AS code of higher import duty rate on the goods. This may sound weird, but technically we see that in many cases, even if when it comes to the ingredient, this is a very like we walk on the line between what it could be this 50%, it could be this AS code, or it could be that AS code, and in such case it requires very in-depth technical knowledge on the product, and also the inside knowledge on the classification rule, the GRI, in order to argue with the custom authority on which is the right HS code for the product. So next slide. The next one is the origins, the preferential origins. So normally importer will claim the preferential duty on the basis of the certificate of origin, the CO, issued by the exporting country. However, from our experience, we see that very common error on the CO, which can be identified as like erroneous origin criterion. For instance, the correct one should be CC plus SB, which is the change in classification, plus some specific processing in the export country. But due to negligence or some other reason, the origin criteria on the CO is only CC, so the plus SB is missing, for instance. Or the exporter, they fail to tick on the box, third-party invoicing box in the CO. So this is also very common because, as we know that now the seller and the manufacturer may not be the same person. And in such case, the manufacturer, they ship the good directly to the buyer, but it is the seller to issue the invoice. So in such case, the manufacturer need to tick in the box of third-party invoicing in the CO. Other issues is the RVC, indicating the RVC or inconsistency in presenting the goods description, missing some part, because we know that the goods description is sometimes very long, metal, plastic, etc. And due to the limited in the space, they may missing some part, and it is also a reason or a sport for the customer authority challenge. So next slide. Another one issue is the export production. So export production can consist of the toll manufacturing arrangement or the contract manufacturing arrangement. And we know that here in Vietnam, for toll manufacturing or contract manufacturing for export, the imported material won't be exempted from import duty. And it is the key issue, because the custom authority, they will impose very strict control and supervision on the imported material that are exempted from the import duty. They will require the manufacturer to declare the material consumption threshold, and they need to conduct the update on the inventory on a real-time basis. And any failure in following or complying with this requirement, which lead to the difference between the number on the book and the actual inventory in the warehouse. And then it could lead to the risk of duty-free material leakage, and custom authority, they come and check, and they will impose the penalty on such difference. So that is one for my section. So in next section, my colleague Vinh will present to you on how to manage a custom audit. So over to you, Vinh.
Thank you, Trung. Thank you for walking us through different types of customs audit and the issues, the areas of focus that customs authority would have when they conduct an audit at the company. So in this session, I will just highlight a few preparatory actions that the company can consider in order to manage a customs audit and minimize any adverse impacts to the company. Next slide. So first, what can you prepare before any customs audit occur? First, you know, customs audit in Vietnam is very aggressive and very common. Nearly most of companies that have import-export transactions would be subject to customs audit at a certain point of time. So it is very important that the company have a set proper internal check system to make sure that supporting facts, supporting figures, data, serving your custom declaration are properly filed, um, and avoid any like leakage in terms of, for example, in case of export production, avoid any like mismatch between your actual inventory and what is in the book. That's just one example. So system, the company system is very important to minimize like errors, minimize issues, non-compliance issues when there is an audit. In relation to internal check, this is not just the check on your internal company system, but I think one point that you should note is that the compliance, the work conducted by your customs broker. This is a very important area because most of companies engage your customs broker to handle the customs declaration. So the point is that if there is any error in customs declaration, whether or not you can claim for compensation or any recourse action from your customs broker, that's a commercial arrangement between the company and your customs broker. But from the customs authority perspective, if there is any non-compliance issue due to an error made by your customs broker, it is still a non-compliance issue of the company itself. That means the importer of record or the exporter of record. The customs authority will not claim the customs broker, but any non-compliance or liability would be on the importer or the exporter. So check on custom broker is very important, play an important role in managing non-compliance or managing a customs audit at the pre-audit period. Second, to enhance like compliance at the company should consider conducting regular compliance training for employees. It's not just the training for the personnel who are directly involved in the customs procedure, but it is necessary to run that kind of training on other employees in other departments that are somehow related to providing inputs, statistics, information, serving the customs declaration, because it is important to make sure that all departments, divisions in the company align on certain issues, on certain positions for a transaction of a company, to avoid any like inconsistency in the perspectives, in the views between departments in the same company. And then last, another measure during the pre-audit period for you to manage a custom audit is to seek advance ruling. Yeah, as my colleague mentioned, there are still drawback and limitation in application for customs advance ruling in Vietnam in terms of timing, how complex it is to obtain customs ruling. But where it is possible, particularly for like high value transactions, if possible, so the company can consider to obtain customs advance ruling. Next slide, please. So during the customs audit, so whether you want or not, if there is a customs audit, so it's important how you can manage the process, because a customs audit, based on my colleagues' presentation earlier, the whole process can last for many months, depending whether it is a post custom post PCI at the customs authority office or at the declarant's office, or whether it is a special audit. It can last 3 months, 6 months, even to a year. That can be the very normal in reality. So once the company receives the customs audit decision, it is important to identify what is the scope of the, like for example, in the post clearance audit inspection, what is the scope and who are the authority in charge. Why we need to identify the scope of the audit? It is because based on the scope, so you can determine what are the limit, the scope of the information documents that the company is required to disclose. We should avoid the situation that the company provide information or documents more than what is required under the scope of that audit. Next, the company should identify potential issues based on your normal routine check and based on the scope of the customs audit. You can identify what would be the potential issues, whether it is customs valuation issue, or whether it is a classification issue, or whether it is preferential origin, or whether you have any issue with the certificate of origin, something like that. So based on the potential issues that the company identify, then you can develop your action plans. What are your defending positions? What are your arguments? How you are going to present the issues to the customs authority if the company is questioned, and what kind of supporting documents, information that the company should prepare to provide and support for that issue. Next is the company should assign relevant staff to handle the audit with proper care. What I mean is that the company should assign like one contact point in the whole audit process in order to receive queries, questions from the customs authority, and also to provide inputs from relevant divisions, departments in the company in order to provide the response to the customs team. We should avoid the situation that the customs authority may have different opinions or different explanations from various divisions, departments of the company on the same matter, because it just triggers more suspicion and create more uncertainty in one issue being questioned by the customs authority. So it's important that we have one point contact who handle the whole audit process. Next, so how, in terms of core attitude, how should we cooperate with customs authority? Number one rule is show cooperation with the customs authority, of course, within what is required by law. When they ask for information, when they ask for documents, so check whether it is within the scope of the audit. So show cooperation with them, but of course, firm and prepare for your defending positions. Once the customs authority finish their field work for the audit, they will issue some kind of draft audit conclusion. This is very important for the company to review carefully this kind of draft or audit conclusion to see whether the issues or your discussions with the customs authority during the fieldwork process is properly reflected in that draft minutes. Whether there is any point you need to correct or you need to provide further information to explain the issue in order to gain the most favorable outcome as possible on an issue, and whether such kind of presentation of opinion in that audit conclusion would provide you with the best legal position for your appeal letter if it must come to an appeal. Another pressure during this process is, so that's on the content of the on the audit conclusion, and you may work with your internal counsel, or you may work with external counsel lawyers in this process. And another pressure in this process is timing, because under the law, you would just have certain limited time to respond, to provide opinions on the audit conclusion. So make sure that the company can manage that timing issue. And as as I said, so the whole process involves complicated customs issues, legal issues. So the company should consider seeking external advisor, assistance, advice to provide you with the best legal position in defending your issues. So that comes to the end of our presentation. So now we come to the Q&A session. So we received just one question. Maybe Trung, can you please respond to this question? So the question is, what triggered a special audit? How is it different from the PCI? So I think the presentation partly mentioned that, but Trung, can you briefly explain it again?
Yes. So as I mentioned before, one of the reason for triggering the SA is that when the PCI as the declarance office has been completed, but the custom authority, they cannot make the conclusion. They don't have sufficient information to conduct the conclusion. Then they will escalate it to the specialized audit, the SCA. But it's just one of the reasons, and in practice, we see that it's very rare in such case, because normally when the custom authority, they conduct the PCI at the declarant office, they will have their own conclusion. It's almost no case that they will not have any conclusion once they already conduct the PCI at the declarant's office. So it must say that by law, the law give a very wide speech or very much discretion, give much authority to the custom authority to decide whether they will conduct it as a PCI or they will conduct it as an SA. And as I said, PCI is the more common form when talking about custom audit in Vietnam, it should be the PCI instead of SA. However, SA do happen, and in project we see that SA will happen in this way. So normally, the GDC or the PCI department under the GDC, they will conduct the SA on the provincial custom department. So they come and they check all of the activity, import-export activity that happen in a specific provincial custom department. And once they conduct such inspection, they will detect certain errors, certain violation in the custom department, and that such violation may relate and normally related to specific enterprise. And in such case, they will request the provincial department, custom department to conduct remedies. So in that case, the provincial custom department, they will contact with the enterprise, and they may immediately impose the decision. So it's more dangerous here, because in such case, the enterprise, they normally will not have chance to discuss or to command or to negotiate with the provincial custom department, because the decisions is not by the custom department, it's by the GDC. So it indirectly it works in an indirect manner, and in such case, it's more dangerous for the enterprise as compared to PCIs.
Okay, thank you, Chung. So we move to the next question. The question is, most FTA require record retention of 3 years. So does Vietnam Customs require records relating to FTA to be kept at 5 years instead for customs audit requirement? Chung?
Yes, under the law here, all of custom document must be kept for 5 years. So because the PCI, the statute of limitation of the PCI is 5 years, so the document must be kept within 5 years. That is for custom code. For the FTA, of course, we see that they only require 3 years. So that is the commitment under the FTA. Is that not means it just means that under the FTA, the authority or the importer or exporter are only required to retain the record for 3 years, and it's normally happened in the case of the relating to the issuance of the certificate of origins. So it means that in such case, the exporter or exporting country, they limit their liability within just 3 years previous. In order, in the case that the authority of the importing country require any verification or explanation relating to the CO. So that is just limited in the obligation under the FTA.
Thank you. So our next question is, Fred asked, clarify the new APA system, what business products are or are not eligible to get APA. So I think Fred mean the customs advanced ruling, not APA, because APA is for transfer pricing. So I guess yeah, the question is about customs advanced ruling. So Trung, can you take this question?
Yeah. So APA we know that it done with the price. So as I said, advanced ruling on custom value is not practically not available in Vietnam at the moment. And also, as I said, custom authority, they completely ignore on TP arrangement. So even for the APA, we all know that APA is now still though it's already in place for couple of years, is still a new issue. From my not as much as I know that even in Vietnam, the number of APA is not just a handful. So
Okay.
again, for custom valuation, there's no APA will not work in this case.
Okay. So thanks, Trung. So the last question is, the company's previous customs audit was by local provincial customs. However, the company is informed that the next audit coming from Hanoi. So question is, Hanoi customs more demanding, and do they work with provincial customs? So I think what you mean, the customs audit by Hanoi is the customs audit by the General Department of Customs, not by the local customs authority. Without knowing of course, the scope of the audit, and normally the audit under the GDC would be like more intensive in terms of the scope, and the issues covered by the audit from the GDC can be like an industry issue that affect not just one company but several companies, but based due to treatment from the local customs authority, which somehow for certain reason the GDC would think it differently. So they may conduct that kind of audit. In general, it would be more serious or more intensive than the local audit. And whether they or not they work with the local customs provincial customs authority, if the issue is concerned to is related to like previous treatment with the local customs authority, yes, they would definitely work with the local customs authority for the purpose of background, of course, of the audit, because most of the declarations were declared. So most of the declarations were declared with the local customs authority. So they need to check with the local customs authority as a matter of background. So we have no questions, and with that, I would like to thank Jaco and Trung, the speakers, for speaking at the event today. And we thank you, the participants, for joining our webinar today. We will circulate the slides shortly after the event. Thank you very much for joining the webinar today. And we hope to see you at other coming webinars from us. So just follow our news, and thank you and goodbye, and have a nice day.